Good afternoon. Thank you for joining us. We are about to get started. I just wanted to do a quick sound check. If you could let me know if you can hear us, also if you can see us. Thank you. Well, good morning and welcome to today's webinar. I'm Beth Hawley with the Arizona Realtors, and we're proud to bring you these free webinars designed exclusively to keep you updated on issues in the industry. Today's presentation will be about 45 minutes long. If you have questions during the webinar, please write them in the question box and we'll try to get them answered at the conclusion. If you would like to change the size of your webcam, simply click on the line separating the webcam in the PowerPoint presentation and drag. Also, as always, today's webinar will be recorded and available next week on our website at aaronline.com. So today we have Patrick MacQueen, Esquire, founder and partner of MacQueen & Gottlieb. Patrick's 14-year legal career has been highlighted by work primarily in the areas of real estate, transactional law, and real estate litigation. So welcome, Patrick, and thank you for joining us today.
Thanks so much. So I put this class together, this webinar together, because I wanted just the message to get out about a kind of a terrible story that I have involving LLCs, or I don't personally have it, but a good friend of mine who's a real estate agent ran into some significant trouble, and we'll get into his story of not having an LLC and kind of what happened to him in a little bit further into the presentation. So that was the primary reason, is to sort of outline the importance of an LLC. And secondly, there are significant changes to the Arizona Limited Liability Company Act that have gone through in 2019, and we'll talk about those changes. It changes things for anybody who owns an LLC, and now there are certain things you need to do to be in compliance with the Act, and we'll talk about consequences of not being in compliance with the Act. You definitely do not want to be out of compliance with the Act, because then it's effectively like not having an LLC altogether. Go ahead and flip the next slide. I've taught a few webinars, so you guys can see my qualifications here. I've been doing this 14 or 15 very long years now. Real estate law is all we do, is all I do. We do a lot of LLC formations, and so we see a lot of the issues that come up with LLCs. We are experienced with issues involving piercing the corporate veil, which is something we'll talk about. And we see a lot of investors coming in from all over the place, not having LLCs and not having personal protection for one of their greatest investments. They're very easy to set up, they're very easy to maintain, and so if you're not having them, you're really risking a lot. Go ahead and change the next slide. So the teaching points today, they're on the board there, or they're on your PowerPoint presentation. What is an LLC? Why form one? We've already touched on that a little bit. We'll get into some recent trends and recent developments. We've already talked about that. There are new changes. Any new LLC that is being formed as of August 30th, 2019 must have certain new language, and any existing LLC that's been formed prior to August 30th, 2019 must amend their operating agreement to have new language. And so the amended act actually affects everybody. We'll talk about an operating agreement, what it means to have an operating agreement, and then we'll talk about how to avoid disaster situations. Go ahead. So what is an LLC? An LLC is a corporate form. It's not a partnership, it's not a corporation. And I've got a little picture in the upper right-hand corner of that slide, and it says Limited Liability Corporation. That is not what we're talking about here. In Arizona, there's no such thing as a limited liability corporation, okay? There's corporations, there's partnerships, there's limited liability partnerships, and then there's LLCs, limited liability companies. But almost every day I hear somebody call it a limited liability corporation. They're not limited liability corporations. So I put that there as somewhat of a joke. They're limited liability companies. And a limited liability company is a hybrid between a partnership and a corporation. And so everybody knows you have a corporation to avoid certain issues or to protect certain personal assets. And you have a partnership because we like the way those are taxed, as opposed to a corporation, the way that corporations are taxed. And what an LLC is sort of a hybrid between those. You get the personal protection, and then you have a different flow through taxation. We're not going to touch too much on taxation. That's a CPA issue. We're more likely, or we're going to largely focus on the personal asset protection that LLCs that are properly created and properly maintained have under Arizona law. Okay, and so with an LLC, again, it's a limited liability company, not a limited liability corporation. We have owners, and the owners are called the members. Okay, and the governing document is the operating agreement. And what we have to form an LLC, a limited liability company, are articles of organization, or articles that you'll need to file articles in order to set up your company, your limited liability company. Okay, next slide. So again, I've got the LLC little joke box in the upper right-hand corner calling it a limited liability corporation. We're not a corporation. It's definitely not a corporation. But basically, an LLC is so easy to form that it's surprising that not everybody's doing them. They're very flexible. They have pass-through taxation. They're inexpensive. You do not have to maintain minutes. You don't have to have annual meetings. You just have to comply with the act and your operating agreement, and that's really it. And so they're very, very flexible documents. And they're very, very flexible companies, because you can add members later, you can take members away, and they provide the same personal asset protection as if you were in a company or owned a corporation. So for instance, the reason that somebody may own General Motors as just a regular shareholder is because, guess what? If General Motors gets sued, that individual investor does not have personal liability. Same thing in a limited liability company. It's your company, but you as a member cannot be sued personally for an act of the corporation. So it's a huge asset protection mechanism. The other issue is that in some instances, we can maintain privacy. So if we have an LLC, as opposed to transferring real property by virtue of a conveyance, a warranty deed, which is a public record, what we can essentially do is say, listen, I'm going to swap out members of this LLC, change the operating agreement, change the articles a bit, and no one's ever going to know that I just transferred real estate. And so it's a non-recorded transaction, and it allows for people to maintain certain privacy that they want to maintain. They don't want people knowing that they own certain real estate. There's also anonymous registration states, and what I mean by that is, in Arizona, when you file your articles of formation or articles of incorporation, you're telling the Arizona Corporation Commission who's the owner, who are members, who's going to be the manager, okay? And that's public record. If you're smart enough to know where to go, you can find that information out. It's pretty easy to find. Well, in some states, like Nevada and Delaware, you can actually have an anonymous registration. And so literally you can have a corporation and nobody, or an LLC, and nobody will know who truly owns it without some significant digging. So there's some interesting sort of ways to own property, and you can do it almost anonymously in certain jurisdictions. You can transfer it anonymously in certain jurisdictions. And so it's a very flexible way to transfer real property. Now, LLCs are not just used for real estate. That's the primary use. That's primarily where I see them. We set up single member LLCs to own one piece of property or one piece of investment property for landlords, for owners who have a VRBO, or for those who have just raw land that they're eventually going to develop. Okay, so those are easy LLCs to set up. They have a single purpose. They have a single member, and it provides asset protection if somebody hurts themselves at the property, etc. That's the primary mechanism that I see them being used for. Now, I also have clients who hold patents or other trade names or other technology in an LLC, because what they don't want is that LLC to be invaded or that technology to be taken by some act. Okay, so imagine if I'm out there and I get in a car accident and I own these patents. Well, if my LLC owns the patent instead of me individually owning the patent or certain technology, well, guess what? My technology stays safe. It cannot be invaded by creditors because I've got an LLC. The LLC owns the asset as opposed to me personally owning the asset. So it's very flexible. There's estate planning. You can have certain transfers upon death that are addressed in an LLC operating agreement. And so it's not just for real estate, but that's primarily where we see it. Go ahead and switch. So I wanted to get into this particularly disturbing story about a real estate agent that I know. He's done quite well for himself. He had a number of rental properties, and he had always asked me, hey, Patrick, do you think I need to put these in LLCs? And of course I said, yeah, of course you do. You know better. And he kind of said, yeah, I do know better. And he had this property, and there was a guest at the property. There was stairs as well. The guest at the property that he was renting to tenants was walking down the steps. She fell, she was pregnant, and she lost the baby. Terrible, terrible story. He didn't have that property in an LLC. She was able to sue him. She was awarded $3 million, and now she can take every single property, because he didn't have any other income except for rentals and certain real estate business. She can now take every single one of those properties, and she's entitled to them because she has this $3 million judgment. Had he had each of his rental properties in an LLC, the best case scenario for her would have been she could have taken that single property that he owned. Okay. At worst, that one asset would have been at risk. But now he's got a $3 million judgment, and he's kind of stuck. So that's a horror story. I've seen ceiling fans fall on pets and owners get sued and then they didn't have an LLC. I've seen slip and falls and insurance didn't cover it, and had the person had an LLC, well, then they wouldn't have lost personal assets. And so I hear the horror stories. These don't come up all of the time, but when they do, they're pretty significant and pretty scary. And so, our recommendation for folks that have rental properties or other sorts of investments, consider putting it in an LLC. Okay. Now, there's a couple of other cases out there about piercing the corporate veil. And when you have an issue of piercing the corporate veil, well, let me back up a little bit and explain what piercing the corporate veil means. Okay, so we have this corporate veil. It is a veil. It's sort of a shield of protection around your personal assets. Okay, by virtue of you having a corporation, by virtue of you having an LLC, your personal assets are protected. Okay, so it's this veil of protection. Now, the concept of piercing that veil comes in when somebody is not properly utilizing their LLC. So, for instance, if I'm commingling funds with my personal funds and my LLC funds, yeah, there's an issue there that may allow somebody to pierce the corporate veil. If I'm not recognizing, I'm not honoring that corporate form, that corporate LLC form, then somebody can do what's called a piercing the corporate veil as part of a lawsuit and say, now I get Patrick's personal assets because he was not properly maintaining the books, or he was committing fraud, and the only reason he had an LLC was to hide behind the LLC. So normally an LLC or any other corporate form is going to provide you with great personal asset protection. But if you're not utilizing the LLC or other corporate form properly, then the issue of piercing the corporate veil comes in. And you're basically, the argument is that you're using your corporation as yourself. And so there's no real corporation to recognize. And so we see it in very extreme cases. There was a case in, I believe, Wyoming that came down recently where somebody's out there committing fraud, they're undercapitalized, and they hid behind an LLC. And it was obvious to the court in that particular situation that this person was simply hiding behind an LLC. You can't do that. You have to have bank accounts, you have to have records, you have to treat it as a corporation. You can't treat it as your own self, okay? Another issue that came up, it's not as significant as the one in Wyoming, but this was in Kentucky. There was debt or an obligation that was owed to an LLC. The member of the LLC attempted to sue in his own personal capacity, and the court said, no, you got to sue on behalf of the LLC. The money's owed to the LLC, not you individually. So minor issues come up every once in a while with LLCs, but for the most part, they are the way to go. The other issue that we sometimes see or run into is a securities issue. And so if you're out there selling membership interests as if they're a security, well, you have to have the proper registration with the SEC to do that. Because what we don't want to have are you selling membership interests and them being traded like a security is, like a stock is on the open market, okay? And then the other issue that sometimes pops up that we sometimes see are LLCs that have claims. You know, maybe they're a plaintiff in a matter, or they're attempting to evict somebody as an LLC, or they have a debt that's owed to them as an LLC. Well, if you have one of the members file a lawsuit on behalf of the LLC, you can't really do that under Arizona law. Okay, the judges are starting to see this as a trend. Like if I'm, imagine I'm not an attorney. If I wasn't an attorney and I owned an LLC, I couldn't represent my LLC in court. Okay, so what we see sometimes coming up are courts saying, no. If you're a member of an LLC, that's fine, you can sue, but you can't represent the LLC because you're not an attorney. So you're getting in the unauthorized practice of law by owners of LLCs who are suing on behalf of their LLCs. So just something to keep in mind. If you have an LLC and you need to sue somebody, you should be an attorney, or you need to get an attorney to help you with that. Okay, next slide, please. So I wanted to also bring up, this is sort of the second main theme of the course today, effective for LLCs formed after August 31st, 2019. You have to have new language that incorporates the revisions to the Act. Okay, you must have new language. And if you have an existing LLC that existed prior to August 31st, 2019, by August 2020, you have to have the new language. And so basically you need to amend your existing documents. And some of the changes are to sort of match Arizona law to what the rest of the country is doing. There's currently no fiduciary obligations in connection with members. So members don't have fiduciary obligations to each other, and now they're going to. Or you could eliminate certain obligations in the LLC documents. For instance, you could eliminate the duty of good faith and fair dealing. Well, now you really can't do that. There was really never an obligation to disclose conflicts, which is sort of a fiduciary duty issue. Now you have to disclose those. There's also changes to the manner in which distributions occur, the indemnification, which basically says that the LLC has to indemnify members, if the members are sued individually. And then there are certain appraisal rights that are more solidified in the new Act. But the big thing is anything new, any new document or any new operating agreement formed after August 31st, 2019 has to have new special language in it, okay? And any of those that were formed prior to August 31st, 2019 must have amendments to their documents by August 2020. So there's a little bit of a grace period in there, but it's a fairly significant change. And so that's one of the reasons we wanted to alert everybody to this new change. Go ahead and switch. So the operating agreement itself is another sort of big topic when we're talking about LLCs, okay? You don't have to have an operating agreement in Arizona if you're a single member LLC. In other states, that's a requirement. It's a recommendation that you do have one though, okay? And the reason you want to have them will be on the next slide, but basically an operating agreement is sort of the governing document between you and any other member of the company, okay? It addresses spouses, rights to transfer, classes of membership, death and disability, and who actually has the membership say or the control to do certain things. Who's going to manage this? Who's responsible for these major decisions, or do these major decisions need to be voted upon and considered in that fashion? One of the things that comes up a fair amount of times is, what happens if I have a partner and my partner's wife, or I'm sorry, my partner dies? Well, now under Arizona law, I just became a partner with his wife, and that may not work for me. Okay, and so they have certain provisions in operating agreements to address what happens if his wife takes over. Okay, so that's a big issue. The right to transfer is another issue that needs to be considered. When we're talking about rights to transfer membership interests, what I don't want to have if I own an LLC is my partner or the other member in the LLC willy-nilly transferring a membership interest to his cousin who has no idea what the heck is going on when it comes to corporate law or real estate or anything else. And so there are certain restrictions you may want to put so that transfer can't happen. Another point in a lot of operating agreement negotiations is the formation of classes. You may have the starting guys who started this company have a preferred distribution, and then people who came in later who are investing in the real estate or whatever it is have distributions that aren't as preferred or aren't as high or aren't as good as those initial folks that started the company. We sort of touched on the death and disability. What you don't want to have is a situation where somebody automatically, by operation of law, becomes your partner or becomes another member because you don't know anything about them, they don't know anything about the business. And so you want to have provisions where, listen, if there are certain distributions that need to have been made to the member, and we can buy that new member out, that new wife or that new husband that we never really wanted in there in the first place in there, let's do it, right? And so that's an important provision. These are not all of the provisions that you need to consider, but these are the big ones that are up for discussion in most instances whenever you have multiple members, okay? And then control and decision making. If you're okay with one guy running the show or one gal running the show, perfect. Give them all of the authority in the operating document to make decisions about taking on debt, getting a mortgage, guaranteeing certain obligations, buying certain properties. But if you're not okay with that, well then, hey, we need 100% consensus on these certain issues. And so an operating agreement, standard operating agreement, is going to address all of those items. Next slide. Okay, now we set up, and there exists a number of single member LLCs, which means it's just one person, one owner of an LLC. And so the question becomes, well, if I'm not dealing with other members, do I really need an operating agreement? And I would say for the most part, most people who have an operating agreement are single members. It's one member, they own real estate, they rent it out to somebody, okay? Or they VRBO it or short-term rent it or are holding it. Do they really need an operating agreement? The answer is, under law, they don't have to have one, but they should. And the reason they should is, number one, to address business succession, okay? If I pass away, I want the business, I want the LLC, and I want the real estate to go to my kids. So you put that in the documents. Sometimes an operating agreement is a requirement by a lender. If you want to take on financing to buy more properties or to put debt on a particular property to buy it, a lender is going to say, you need an operating agreement. We want to see what you're really doing behind the scenes. We want to know that you're properly formed and that this is a true LLC. Therefore, we want to see the operating agreement. The other issue is, at some point, you may want to take on additional members, additional investors in the LLC. And so if you've got this baseline document that says, here's how these new members are going to be treated, here's what we do with them, here's how they get distributions, here's what their role is, well, now you have an operating agreement to do that. You don't have to start from scratch. And then, of course, that alter ego issue, that piercing the corporate veil. Alter ego, piercing the corporate veil, they're very synonymous. When you have an alter ego claim or a piercing the corporate veil claim, you're basically saying that the business is the alter ego of the person who owns the business, okay? And so they're very synonymous types of words. But when you have an operating agreement, when you have properly formed articles or filed articles, when you have a bank account, and like I said, when you have a good operating agreement, you can say, look, I've got everything that a true company has, and I've done everything to properly incorporate this. Therefore, the risk of my own personal liability under an alter ego theory or piercing the corporate veil theory goes away. Okay, so do you need does a single member LLC need an operating agreement? I say yes. The law says it doesn't matter, but the sort of standard of care is you probably need one. Okay, next slide. So let's go over the cautionary tips here. A lot of people are getting their information from Google. That's great to start, but Google doesn't have a law license. Google doesn't have a medical degree, and I'm sure there's people on the webinar who are listening who also realize that Google also does not have a real estate license. So it's great to use Google as a start, but it's not the end-all be-all for everything. We litigate a lot of forms that were found on the internet, and that it's sort of funny because people are trying to save money and they're really not saving that much money, and then they end up getting themselves into more and more trouble. Second bit of advice is to seek tax assistance whenever you have an LLC. The general rule is that the LLC is going to have pass-through income. There's certain elections you can make to be taxed a little bit differently. And there are ways in which you can avoid self-employment tax. Some of the new Trump tax cuts affect certain deductions you can make on behalf of an LLC. So there's enough new stuff out there that I think you ought to consider having a tax person take a look at your documents and give you some tax advice. There's an election, like I said, you can make to be treated, to be taxed as an S corp as opposed to true pass-through. And that can save you some money if you set that up properly. Okay. The third bit of advice, the third cautionary tale, is the failure to form your entity properly. Again, goofing up in the articles, goofing up with the operating agreement. The other thing is failing to convey the asset to the LLC. Okay. So you may have an LLC, you may have a bank account for the LLC. You may have an operating agreement for the LLC. You may have properly set up this LLC just fine. But what a lot of people forget to do is they forget to convey that property, that real estate, to the LLC such that the LLC now owns it. There's no deed. And therefore, you still personally own this asset. You still personally own the real property. And what if somebody falls down the stairs? What if somebody gets hurt in the pool? What if something... The fact that you have an LLC is irrelevant, and so you have to properly convey property to the LLC. Okay, so that's where we see goof ups. Another goof up, like I said, is not having an operating agreement. If you have a single member LLC, an operating agreement can be literally a page and a half, just to say we're just doing this to comply with certain Arizona statutes. Here are the basics, and it literally needs to be something very short and non-complex. Okay. Fifth bit of advice, or fifth cautionary tale, commingling of assets, commingling of money, failing to maintain the proper corporate accounts is a big no-no, and that gets you in trouble on the alter ego or piercing the corporate veil issue. Okay, if you're using your own bank account, your own personal bank account, and mixing in LLC rents or monies or whatever you're owed, that's a big no-no. And so what I always tell people is set up an account at a completely different bank when you have an LLC. Don't even have that temptation to be moving money around or transferring money unless you can document it properly. And most people don't have the discipline to sort of document it properly. They just want to transfer the money. Big no-no. Have it set up somewhere else. That'll hopefully save you a little bit of trouble. Number 6, multiple properties require multiple LLCs, okay? And this can be kind of a headache, but to me, it's worth it. If I own, let's say, 3 rental properties, each one of those rental properties needs to have its own LLC as the owner, okay? And the reason you do that, let's imagine you have 3 rental properties, 4 rental properties, and they're all owned by the same LLC. If something bad happens at one of those rentals, now all of the LLC's assets, which include the other 3 properties, are at risk. And so you're creating this bigger pool that a creditor could go after. Okay, so each LLC needs to have, each property that you own needs to have its own separate LLC. And to add to that, in some instances, you may want to consider having an upstream LLC that owns each one of those individual LLCs, okay? A little bit more paperwork, but a lot more protection. And so it's something you may wish to consider. Now, I know a lot of you out there represent folks that are coming in from out of state or even in state, and they want to buy rentals. So the rental market's hot. You know, I think a good value add for you is to tell these folks, hey, have you considered an LLC? I run into extremely smart business people, and they're like, you know, I didn't even think to have an LLC. I should have an LLC because it's so inexpensive. It's so easy to maintain. They're so flexible that it just doesn't hurt to have one. And so you can add some value by making that suggestion to prospective clients or clients. Next slide. That's all I've got. I'm happy to answer whatever questions you have, as long as they don't touch on tax. You know, just because I think that's a specialized area that I don't want to touch too much, but I'm happy to answer any questions.
So earlier in your slide deck, you were talking about east to form, and there were some questions from people.
Should have said easy.
Easy. Okay.
Yeah, it was a typo.
Typo.
I apologize. East. Yeah, there's nothing east about them. They're easy. Sorry about that.
No problem. Which is better, an LLC or a P LLC?
So they're two different things, okay? There's a P LLC, which is for a professional, somebody to hold their license in. And an LLC is usually used for investment property or some other asset. So if you are an agent and you want to have a P LLC or a PC, I think that's a great idea. But I want to make one distinction or one point clear about P LLCs because P LLCs are a little bit different. By virtue of you having a P LLC, which is a professional limited liability company, or PC, a professional corporation, there's no asset protection there, okay? That's wholly different and wholly, you know, completely different from a true LLC that holds real estate, that holds any other assets you have, okay? A P LLC, and there's a statute on point, I can send out to the group the statute, but basically, if you're acting as a professional in your professional capacity and giving advice in your professional capacity, or engaging in real estate services in your professional capacity, you want to have a PC or a P LLC, great. But guess what? It does nothing to you individually to protect assets, okay? So a lot of people think, this is a common misconception, a lot of people think, hey, I'm a real estate agent. If I ever get sued, I have a P LLC. And so the only thing that the creditor or the unhappy client can take is the desk that I have, my computer, and maybe some passwords to some login information. No, that's not correct, okay? Your personal assets are at risk if you have a PC or a P LLC. There's a statute that says that. And so that's why you want to make sure your broker has E&O insurance, you want to make sure you have your own personal insurance to cover, you know, if you're in a car accident or whatever. So the distinction here is a PC or P LLC provides no asset protection. And so real estate agents set that up, number one, because of tax reasons. It's much easier to write things off if you have a PC or a P LLC. And they set up for marketing because it kind of looks cool after your name, but there's no personal protection. There's no personal asset protection. An LLC has personal asset protection, okay? But the PC and the P LLC do not. Now, having a PC or a P LLC may dissuade people from suing you because they're going to say, oh, well, he or she doesn't have much in the PC or the P LLC, so I'm not going to sue them. But ultimately, there's a statute that says, nope, by virtue of having a PC or a P LLC, there is no asset protection, which is 100% different than a true LLC that's set up properly. That is a major, major misconception out there. A scary one, too.
Yes, the questions are starting to fly in.
Yeah, exactly. And I will send that statute out so that you guys can see exactly what it says.
So for those people that do have a P LLC, are they also required to submit the new forms and have an operating agreement?
No, the P LLC and PC, the statute really only affects LLCs, a true LLC, not the P LLC, the PC. Those have not changed. Now, you still should have an operating agreement and the basic forms for PC or PLLC, but the Act largely did not touch those two areas,
So
or the amendment to the Act, I should say.
So you have 3 properties. They each have their own LLC. Do they then need their own bank accounts at separate institutions?
I would.
Okay.
Or some way to earmark them, just so you're not getting rents into the same place. They're very easy to set up, and you talk to a good banker, they're going to set that up properly. I would recommend that. Now, I know a lot of people who will have multiple LLCs, and they'll have all the bank account, and it's all one bank account, and all the money's coming in, and they're able to sort of account for that. But that's one factor people look at when you're looking at commingling, and you want to avoid any claim of commingling. And the way you do that is, hey, set one up at Wells, set one up at Chase, set one up at Amtrak, whatever it is. That's what I always recommend. And listen, I'm coming from a very conservative approach here, and so because I've seen so many things go wrong. The majority of times things don't go wrong, but I always make sure that I'm setting things up, in the most conservative way possible, just in case things don't go well. We're protected. Now, I can tell you that I had my own rental property, and initially my wife and I owned this rental property as community property. And so if something happened at the rental, all of our assets are on the hook. And so what I did was I had her convey her interest. She disclaimed her interest in the home to me as my sole and separate property. So at that point, that meant that if something happened at the property, at the rental, the person could come and get my sole and separate assets pertaining to that house. Now, I didn't really have much, okay? So that's step one. And step two is I then conveyed my interest to an LLC that only I owned. And so what we're trying to do is just sort of stack defenses to avoid claims. And so, one of the ways you do that is by having cleaner bank accounts that are easier to address if somebody ever brings up an issue.
So you mentioned earlier that you can form an LLC in another state for property in Arizona.
Okay.
Someone tried to do that, and they were told, like in Wyoming, that wasn't allowed. Is it just the lawyer didn't know what he was talking about, or?
Yeah, I'm curious on the Wyoming issue. So what we see sometimes, because we don't deal with Wyoming too much, but what we see here are a lot of people who have Delaware LLCs, and they also have Nevada LLCs. Now, for a Nevada LLC, you actually have to have a Nevada attorney prepare the documents and file the documents, okay? And maybe that's what the issue was. Same thing maybe in Wyoming. You actually had to have the person Wyoming admitted in Wyoming, okay? So in Nevada, I know for sure that an Arizona attorney cannot go in and file and prepare a document. We, as Arizona attorneys, can do it in Delaware, and then you register the entity here in Arizona, and you're good, okay? But in Nevada, and I'm thinking in Wyoming, that was consistent with what happened there, or I would imagine that's what happened there. So I would consider a Delaware LLC in that instance. I can't form a Nevada one, so you may want to talk to somebody who's admitted in Nevada who can form one there, and then you register here, and that can happen. It just may have been the situation where, like Nevada, Wyoming may have a similar law that says only Wyoming attorneys can form Wyoming companies.
That would make sense.
Mm-hmm.
So if you have personal funds, I love this because this is what I would do. If you have personal funds in a different bank account than an LLC account, can you lend that money to the LLC and repay yourself with funds that way?
Great question. The answer is yes, but, right, there's always going to be a but. You want to document that. You want to have a note. You want to have, you want to make sure that if you're going to act as some sort of lender, you want to act as if a lender would, right? And so, you need a note, maybe some sort of other loan agreement, maybe a deed of trust, those sorts of things. So yes, you can absolutely do it. but make sure you have the documentation to support that's what you're doing, instead of it looking like you're just transferring money between the personal account and the business account.
So let's see. So you have multiple properties, multiple LLCs, and multiple bank accounts, but you have one deposit account for everything, and then you distribute out to the proper accounts. Is that good business, bad business?
I think I'm okay with that, as long as you are good at, you're marking where these really need to go. I think that's probably fine. I don't know if I understand the question exactly, but I think I do. And I think I'm okay with that.
So where's the best, what's the best way to set up an LLC? They own about 10 different rental properties under their name. How would you direct someone coming in?
Sure, it's pretty simple. Go to the Arizona Corporation Commission website, file articles, and get it going that way. And then ultimately, once your articles are approved by the Arizona Corporation Commission, there used to be a publication requirement where you would have to publish the fact that you're filing these articles, and then once the articles are published, then you're official. But now that's no longer the case, at least in Maricopa County. So you would go to the Arizona Corporation Commission website. It kind of goes through step by step. Now I'm fairly certain you can do it all online. You don't have to go in. You don't have to send documents in. So the Arizona Corporation Commission website is going to be fairly helpful to at least get you fill in the blank kind of stuff. If it's more of an operating agreement that you need, then you're probably going to need to find that somewhere. And then ultimately, if these are rental properties, I think that's what the question included, you're going to want to convey each of those rental properties via deed to the LLC. I don't know if that answers the question, but take a look at the Arizona Corporation Commission website. People can do these on their own. Some people don't want to because they're like, I don't have the time. I don't want to dig into this. I don't know exactly what I'm doing. You're also going to have to get what's called an EIN number, and that's your tax identification number. And so that's a very important part, because most of the time you won't be able to get a bank account without a separate EIN number. It's like a social security number for people. You're not going to be able to get a bank account without that. So you have to apply for an EIN.
Great. Can you reapply for an LLC? If not sure what the question is here.
Expired LLC, maybe?
Yes.
Yeah. So sometimes you can apply. You can reapply if you if it appears that it's been terminated for some reason. Sometimes they're administratively dissolved. Sometimes they've got dates in them that dissolve them, that result in a dissolution. But in most instances, you're going to want to go to the Arizona Corporation Commission website. I'm assuming this is an Arizona LLC. Take a look to make sure that that LLC is still available. Somebody may have taken the name. And that's actually a part of the steps that you should go to informing the LLC. Number one, you're going to want to make sure there's a name out there for you. Otherwise, you're going to have to rename it. So yeah, part of this is going to the Corporation Commission website, making sure the name exists. And if it's an expired name, you still may be able to get that and reopen it, or just get the new name. Sometimes you have to buy the name from some of the people, but usually, the conventional thinking, the easy way of doing it is just using the name of the address. So if it's 123 Main Street, and you do 123 Main Street LLC, I can almost guarantee you that one's been taken, but come up with some sort of combination, or people use their initials. So it's pretty easy to form an LLC and get the name going. But as far as an existing one, or one that was previously existing, sometimes you can reinstate them. It just depends on why it was dissolved and whether somebody else now owns it.
Can you convert a PLLC to an LLC, or is it just?
Yeah, there's articles of conversion, and so sometimes you can convert a corporation to an LLC. So there's all sorts of ways you can convert. It's a fairly inexpensive process. There's a list of forms on the Arizona Corporation Commission website. And it's sort of a self-service thing where you can kind of click on there and say, I think this is what I want, and it'll give a description of what it is, and you pay $25, and these articles of conversion, get printed out, and you send it back in, and now they're on file and you've converted your entity. Now you're going to want to talk to a CPA to make sure that that conversion doesn't affect you for tax purposes, but that's not a bad idea sometimes.
So I'm just continuing to get a lot of comments. Concerned agents who have gone through the P LLC process and now they're like, oh wait. So your general advice is convert everything to an LLC?
Well, not your licensing issues. Your licensing should be PC or PLLC, to the extent that you want some ease of write-off ability, if that's even a word. But the fact that it is a PLLC or PC does not provide asset protection if something goes wrong. What you have for asset protection in your capacity as a real estate licensee is insurance, your E&O insurance, okay? What we're talking about is LLCs for rentals, for investment properties, those sorts of things. So hopefully, I know it is a very confusing issue because a lot of people are like, oh, it's a PLLC, I've got asset protection. Not exactly, okay? And so I will send the statute that sort of addresses that, and hopefully that will further clarify the point I'm trying to make. You have a PC or a PLLC, that's great. As an agent, that's fine, but it really helps for marketing. It helps for writing off taxes, but it will not get you out of personal liability. Okay, if you commit professional negligence. LLC, completely different. It's a limited liability company. You own it, you run it, but it's not for your real estate services. It's not for you acting in capacity as a licensee. It is for you owning real estate, you dealing in real estate, you owning rental properties, you owning investment properties. Okay, so two totally separate concepts here. Hopefully that helped a little bit.
Yeah, I think so.
Okay.
So that is all the time we have for questions. I would encourage anybody who still has questions or confusions about what they should do, what they want to do, to reach out to Patrick or your own attorney. We will send this out recording wise, and you have his contact information on the screen. So we hope that you enjoyed today's presentation, and we'll see you again soon. And thank you very much.